bill hearing that we have scheduled for today. Steve, oh, there he is. Steve Solomon has a few words to share with us. Thank you. I was just lamenting that my sack lunch came with an oatmeal raisin, and your cookies look better. I'm going to trade in. Okay. Okay, so everybody on the floor saw that we will be getting our bill back to committee. I'm not sure which day we'll be looking at that, probably next Wednesday. But I looked at at Mason's rules, and we will be dealing with the amendment first thing. We do not have to go through a hearing of the whole bill over again. So it'll come to us with the amendment attached, not amended, but with it attached. And I just want to say I appreciate the conversation that we had on the floor and the civility. Thank you. Representative Neighbor.
Thank you, Madam Chair. I just would like to add to your comment, if I may, for just a moment. I think we have a lot of new people on this committee and people that haven't been as on the floor quite as much with amendments and things. So this is just a teaching, a learning opportunity that I had when I first joined in the legislature. And that was just courtesy for the committee chair and leadership to let them know you have an amendment, because then they can sometimes help explain or help you write exactly what you want. Maybe you had that already done, but it gives them a heads up as to what's coming so that they're prepared too. And it's just a learning issue, and it's not that anybody is against the amendment or for the amendment, but it certainly can help in support of the amendment and discussion. And I just say that not from being pro or con, but certainly it's I consider it a fairness and respect guideline. So thank you.
Thank you. But I wasn't for sure, but I was fairly certain that we were getting the amendment, and our ranking member and I have a good relationship of communication. So yeah, I appreciate that, though. If anybody in the future, if you have something that you don't have to tell me, but it's helpful if we're all on the same page. And I think we are all on the same page on this bill. It's just getting the language right. Okay, so we're going to open the hearing on House Bill 2299, and I'll call on Jesse to give us a overview of the bill.
Thank you, Madam Chair. Good afternoon, committee. Today's hearing is on House Bill 2299. So this bill amends only one statute, which is 382270. It's the statute that directs the court to enter orders regarding an adoption of a child when parental rights have been terminated. So at this point in the process, the parental rights have been terminated, and before the court are two options for orders. So current law, subsection A, directs the court to enter, in paragraph 1, an order granting custody of the child for adoption proceedings to the secretary, and the secretary shall have the authority to place the child and give consent to the court for the adoption of the child. This subsection states that the secretary's consent is the only consent required to enter the order of adoption. And the bill first amends, and so then the bill amends this section, that this court order, that the court be guided by the best interests of the child when granting this order. So the second type of order you can find under subsection A2. This type of order is one that may be granted by the court in granting custody to the proposed adoptive parents, and the court itself consents to the adoption by the proposed adoptive parents. So this bill amends when a court enters this type of order that any previous order of custody before granting this order shall end. So that shall end part is new. So currently, subsection B requires that in making either of these orders under subsection A, the one for the secretary, the one of the court shall give preference to a relative of the child, and second, to a person with whom the child has close emotional ties. So this bill amends that subsection B to state that when a child is in the custody of the secretary for an order under A1, so that's the order that is giving the secretary the custody and the secretary the authority to consent to the adoption, that the secretary, in doing so, shall give preference to a placement that maintains the child's close and healthy attachments. The subsection directs the secretary to consider certain things when considering a foster parent as a prospective adoptive parent, especially when. So these are instances in which the secretary shall consider the foster parent as a prospective adoptive parent when the child has lived more than half of the child's lifetime with that foster parent, the child has lived more than 2 years with that foster parent, or the secretary otherwise determines it's in the best interest of the child to consider such foster parent as a prospective adoptive parent. So that's subsection B. This bill proposes a whole new subsection C for when a foster parent that is considered by the secretary in that analysis is not selected. That foster parent may request a direct placement of the court of that child and then appeal the decision. The bill proposes a new subsection D that directs the secretary to do certain items to implement these new subsections, these amendments in the section, and the secretary shall be required to develop and enforce adoption selection policies that comply with this section, review those policies, update those policies, apply the policies consistent, develop and provide training for the contractors and employees, and collect data regarding the best interest staffing decisions related to this. The secretary is also required on or before the first day of the regular session to prepare and submit a report to the legislature about compliance with this section. So that is House Bill 2299, and I'm available for questions.
Committee, do we have questions? Representative Howerton.
Thank you, Madam Chair. Would this, sorry, there we go. Would this, so it's from this time forward, is there any way to go back for any open cases that would be maybe affected right now? Or how would that work?
Madam Chair, this bill has no retroactivity. So once this bill is enacted and the effective date of this section, if passed, signed by the governor, all of that, it would be in effect on July 1st of 2023, so if it goes through all the process. And from there on, this section would be applicable.
So would that be new cases, or would that apply to open cases right now?
It would apply only to cases that are open after that July 1st effective date.
So if they're open before that, they would not apply?
Correct.
Well, wouldn't that depend on what your definition is of open? I mean, if.
So the bill's silent as to whether it's an open case, it applies to open cases, or only new cases.
When the judge makes the ruling.
I suppose.
Sure. Okay. Representative Lewis.
In other contexts, I think the judge would apply whatever law was in effect on the date that he or she heard the case and was making a decision. Even if I think there had been like a hearing and the case was still, quote, open, I think he or she would apply the new law.
Okay.
No, I'd argue that they had to.
Okay. Further questions? Representative Wagner.
Thank you, Madam Chairman. Jesse, and maybe somewhat to the committee, did we not have a very similar bill to this last year in Children and Seniors? Is this a totally new direction on this topic? That
Yeah, Mr. Wagner, or Representative Wagner, I can give you some kind of procedural background, and then if there are comments, I'll leave that to the chair. So last year, this committee saw House Bill 2700, and it amended the same statute, which is 382270. So what it did is it required the judge to evaluate certain factors when providing either of the orders. And I can provide that bill to the committee or get more information related to that. But this committee last year, or the predecessor of this committee, did see a bill dealing with this statute.
but this is kind of a different direction from what we had, or is this, how similar is, this isn't that similar. I don't, my memory, it's not that similar. But.
You want me to comment?
I would leave that to the chair.
Okay, so so we had that bill in committee last year, and following that, Representative Humphreys was still working on that, and did we do it or did I do it? We wrote a letter to the Judicial Council requesting a study, and they accepted that and studied it for several months, and then came back with recommendations. And this is not that in its entirety, but it's part of it. Do you want to respond any further? You good? Okay. Okay, further question. Representative Lewis?
Thank you, Madam Chairman. I just want to, as you know, I'm new to the committee, so I'm not all that familiar with.
Representative Lewis, could you get a little closer to your mic so I can hear? Thank you.
I'm not that familiar with the processes here. I just want to make sure I understand the basics here. A1 pertains to essentially where there's been a foster care replacement, is that right? Where there's the custody has gone to the secretary or corporation?
Madam Chair, so at this point, parental rights have been terminated, and so 1 and 2 apply in the instance in which the parental rights have been terminated and they've been in foster care. So both of them can apply to that situation.
So that's my, I'm confused because in A2, give me the scenario of how that plays out.
Sure, yeah, Madam Chair. So this very specifically is you have a child who has been in the custody of the secretary. At this point, there are parents who are looking to adopt said child. The court decides whether or not to grant custody going forward to the secretary to decide who shall adopt a child, or the court itself enters an order deciding who shall adopt a child.
And what determines which way the court goes?
That's not in the statute. This bill doesn't deal with any of the guiding principles for making that initial decision. It would be my answer.
I'm still confused. I don't know if anybody in the committee could try and explain how this works.
Maybe when we have, okay, I'll call on Representative Humphreys, but it might be clarified a little bit during, when we hear from the conferees. Did you want to respond?
I could just.
Representative Humphreys.
There could be other situations, but A2 could also apply to a case where there's a baby's born and for some reason the child goes to a family. They're not a foster family per se, but the mom has granted temporary custody to that family, those parents. And then, as it turns out, the parental rights are going to be terminated, and so that family that the child is with now files a petition for adoption. And kind of in the way our statutes are now, sort of at the same time the parental rights are terminated is the same time the petition is heard and decree is entered for the adoption. So there could be other situations where 2 applies, but I know it applies in a private adoption, but maybe one of the conferees could explain if there's other situations that it would apply in, but that would be one of them.
Representative Neighbor.
This is very close to an incident that we've heard over the last couple of years. And one of the things that came up on in that adoption was that, or that placement, I should say, was that the judge who had made one decision went back and switched his position, and that was because he was friends. He had a relative who was friends with one of the groups going after the child. Can we put something in here that if a judge has any association with the foster parent or to recuse himself of the issue? Because that itself leans sometimes to questionable behavior. Would that fit in here to also add that in there?
You'd be welcome to work on an amendment if you'd
Thank you.
like. Okay, other further questions for Jesse? Okay, thanks, Jesse. Jesse accidentally printed our bill briefs, so we don't have to look at them online. Thank you. Okay, we'll start with the proponents of House Bill 2299, and first up, we'll call on Crystal Hedrick from Foster Adopt Connect. Hi, Crystal, welcome back.
Thank you, Madam Chair, members of the committee. I appreciate you having me here today. My name is Crystal Hedrick. I'm the Vice President of Kansas Programs with Foster Adopt Connect. As you know, I bring testimony before you as a foster and adoptive parent, and also as a social worker who has been doing foster care, child welfare related issues, specifically to adoption for several years. I appreciate this committee and the efforts of the committee in regards to challenging situations regarding adoption from foster care. I was actually at a meeting this morning with Kansas Strong, KU, and some of our other partners, and someone brought up this kind of concept about you cannot change a system until you recognize your role within it, and until you envision yourself as a part of the system that may or may not need fixing. And so I think it takes a lot of courage and bravery to approach conversations like this, and appreciate the time that some committee members have put into HB 2299. So adoption is complex. For years across the country and within Kansas, we've had good intention and talked about good solutions and how to develop policy. One of the complexities of developing policy around adoption, specifically adoption from foster care, is that all families are different. If we took a look at all of our families, of everyone here in the room, we would all have different cases and different scenarios and different factors that would play into those situations, and trying to capture all of that in one comprehensive policy becomes really challenging. And so when we think about other policy that we have, such as our best interest staffing policy that we have today, I was a part of developing that, and it's with certain intention that we put practices and policies into place like that. But sometimes the way that those are implemented and other people's perceptions of those and the way that they interpret that policy, it can take on a different meaning. And so I think that's some of what we're looking at here, and the way that we interpret this policy that's in this bill that's been put before us. Deputy Secretary Keys at one point said to me when I was supported by her in a leadership capacity, she says to me, "Don't let perfection be the enemy of good." And I think that HB 2299 is a step in the right direction for us, and there are good components of it. One of those things is that we continue to focus on what's in the best interest of a child in terms of biological family, sibling connections, but we're also making it a priority to consider the value and safety of the connections that they currently have, and doing that in a more formal capacity. HB 2299 also supports and encourages those who, in theory, really know the child well. So court professionals, case managers, therapists, caregivers, advocates, and those people, this gives them a voice to truly consider what's in the best interest of a child without making assumption that that may always be a biological family in terms of placement or permanency. This solidifies that the sense of safety and belonging with caregivers can be the foundation that some kids need to heal from their trauma, and sometimes it may be a balance of those two things. What HB 2299 does not do, it does not relieve us of our responsibility to prioritize and facilitate safe and supportive relationships with biological family members and siblings. It challenges us to do better in those things, to do family finding earlier on, to make those placements earlier on, to support and encourage those relatives and kinship providers through policy and financial support, to facilitate visits more often, more frequently, longer in duration, and to start the ICPC process early on if necessary. I do have some reservations about in terms of infants. If you consider the duration of a typical reintegration case, you have an infant that comes into foster care at 3 days old and is not placed with a relative because grandma may live in a different state or aunt and uncle may live in a different state. They don't have the ability to come to Kansas and uproot their own children and their own support network. That ICPC process in terms of placement could begin then, but it may not be appropriate to consider an ICPC for placement because it's difficult to work reintegration when a child's placed out of state. So that would prevent us from being able to place that infant with that relative caregiver immediately. So that half of a child's life can go really quickly in terms of the length of a reintegration case, where that's often 12 months or longer. So that would be one reservation that we may need to think towards in the future in regards to revisions and how can we continue to support those situations. The challenge offered to us is not only for professionals in their circumstances. I think that some of that comes back to our caregivers too. And I myself, as a former foster parent and adoptive parent, can attest to this, that we should never question the role of a safe and appropriate biological family member or the path to permanency through those relationships. I can just share a brief personal story that I adopted 3 from foster care, and each of them had relative caregivers in their life. And each of them came to live with me while those people were working to get their home situated to take them. And as we developed relationships and a trusting relationship with one another, that timeline took longer than the initial 2 weeks that we had talked about and turned into months. But we developed really close working relationships with those family members who, in the end, were potential adoptive resources. But after some time, they determined that that wasn't what was best for their family. And that they didn't have the capacity to do that. But it was through the relationship that we built with them that they felt comfortable saying to us, would you be willing to adopt? Would you partner with us in this? And all of our kids have relationships with those people, and they still play an important role in their life today. Holidays and birthdays look a little wonky at our house sometimes. But I think that this bill, the way that I interpret it is that we're challenging not only professionals to take a look at policy and practice, but also our caregivers and the way that we develop relationships with these people and really put kids before ourselves and thinking about how we manage those relationships. There may also be unintended consequences for the appeal components of 2299. If we're establishing and creating a path to appeal, it could be said that we should do that for any potential adoptive family. Limiting that just to foster parents could have some implications for us in biological family moving forward. I think we could take some time to gather that data and analyze that and maybe put together a more comprehensive package in that regard at a later time. But otherwise, I think HB 2299, it is a step in the right direction and would be supportive of that and look forward to working with this committee as we continue to push that forward. I stand for questions when appropriate.
Thank you. I think we just have 2 conferees, so I think we'll go ahead and hear from Rachel next, and then we'll ask questions. So next up, Rachel Marsh with Children's Alliance of Kansas.
Good afternoon, members of the committee. Thanks for having me back again. Rachel Marsh with the Children's Alliance of Kansas. I won't recite all of the ways that our members are engaged in adoption. We have members that have very different lenses on the adoption from foster care process, and I've set that out in my testimony. I'm really kind of happy that Crystal was able to go first because she has such a nuanced understanding of the social work lens and on policy and best practice and some of these very difficult considerations. And it opens a door for me to put on my more legal hat as I talk with you today. My background, and it's been a busy session, so the ability for me to answer all of questions as clearly as I might want to today might be a little bit lower than usual, but my background has been in child in need of care, and one of my most common areas of litigation was the foster care and adoption process. And so hopefully I can answer some of those questions for the committee, because what you see in the bill sometimes doesn't make sense until you practice in the field. So I want to start with pointing out the history of what's been the concerns that we've seen around really what is a narrow issue in Kansas foster care. We know that over 90%, and I would have to refer back to DCF data that I looked for it and couldn't find, that we heard during the Judicial Council study, that the vast majority of adoption cases run smoothly without contest, without challenge, and with satisfaction of the parties in the end. So we're talking about a very narrow segment of cases. But we began to hear around 5 years ago at the original Child Welfare Systems Task Force that there were some concerns about cases where children had been in foster care for a very long time with a foster parent. And then later, at the end of what felt like years, there was a choice made to place some of those children in some instances with a relative. And it was hard for judges and therapists and some other stakeholders to really understand what was happening. It was less difficult for me to understand what was happening because of what the law says. The law says the court shall consider first a relative. And that is something that is addressed in HB 2299, that we would remove that requirement that the court first consider a relative when they're looking at placement. So as secretary or various secretaries over time were implementing their standard policies, they were looking at what the law says. If the court is supposed to look first at a relative, we probably are too. But it wasn't clear because it actually doesn't say the secretary is to do that in the statute. So as an adoption practitioner, I was never clear what we were supposed to be doing. What I relied on is that there were some cases taken to the Court of Appeals a number of years ago, and in the Court of Appeals, they directed to courts, not to the secretary, but to courts, that the courts should look at a specific set of factors and should make an individualized determination, not blood, not bond. That's the language from the Court of Appeals. And they had both a foster parent who was frustrated to go up on appeal, and they had a relative who was frustrated to go on appeal, and both cases said, don't look at just making a decision based on status. Individually look at each child. So that was how I ended up practicing. Even though the code itself was confusing to me, the case law was not, and so I focused on the individualized determination, but it still left kind of a conflict. So if we would like our providers in DCF to get us to the outcomes we're seeking, we have to make sure that we're clear in what we're asking them to do. So that's a piece that I'm really actually very thankful for 2299, because it is really opening this conversation up for us to have. What is the right policy? What is the right balance? And can we all be on the same page? I know it's the legislature, about getting there in the best interest of children. So that's the first thing. And HB 2299 specifically states that the focus is on the best interests of the child when you place them in the secretary's custody and you delegate that authority to the secretary. The second piece to answer one good question from earlier is, when does the first section apply versus the second section apply? Practically speaking, from foster care, children who are exiting foster care from adoption first have a parental termination hearing. Then we have a follow-up hearing in some counties. In some counties, you don't even call it that. But after you terminate the rights, you have a hearing called the post-termination disposition hearing. And at that hearing, the judge decides, am I going to directly place the child for adoption, or am I going to place the child in the DCF secretary's custody for purpose of adoption? And so why would a judge do one or the other? Because the only benefits that come from the federal government apply when you choose the secretary's custody. So it's possible for a judge to place the child directly with an adoptive family, but when they do that, they remove the child's access to adoption subsidy and long-term Medicaid. So they hesitate to do it except for in the rarest circumstance. I understand there's only 3 conferees, so I'm taking a long time. I hope it's helpful.
There are only 2 conferees.
Oh, okay. So the second piece, when I write HB 2299 distinguishes the option and role of the court and the secretary, that second piece that you'll see in the bill is it really just is a clarifying. We've moved what the court can do to one paragraph, what the secretary can do to the other paragraph. So we're not trying to mix and match who's responsible for making what decision. So it's really a technical cleanup, but it also can be policy heavy depending on how you understood the previous code to be interpreted. So then you have the issues of best interests, and we have now put it in the statute for the secretary outside of just the case law references. And I've kind of gone off topic a little bit because I've already talked about how there's a little bit of confusion in the case law. So bringing back to the Child Welfare System Task Force. Now you understand why there were some concerns, why there was a request to be studied, but the study doesn't happen immediately. As you know, we can be working on issues for years up here, and we have been. So last year we took a stab at a bill that we thought maybe could address some of these issues, but in my opinion, it probably opened some areas for concern that weren't necessary. So we took a request from the chair and Representative Humphreys to the Kansas Judicial Council, and I'm a member of that, to be transparent, on the Juvenile Offender and Child in Need of Care Advisory Committee, and we took a look at this narrow issue. What is the right answer without damaging adoption for every other child in care that doesn't have any real contests, and we don't want to delay? What is the solution for this particular narrow problem? And how can we bring clarity to that? So the Judicial Council report is part of the basis for my thinking. We wrestled for hours and hours and hours about how can we do this in a way where we address the narrow issue of clarity to DCF when there is a foster parent involved without potentially delaying multiple adoptions, potentially hundreds of adoptions every year. So HB 2299 reflects the Judicial Council study recommendations. It recognizes that we have to consider healthy and close attachments for children. It's not difficult to understand why. I think all of you would easily see that. And we did hear expert testimony at the Joint Committee on Child Welfare Oversight, I think in the fall, that shared with us making adoption selection decisions from foster care is not as simple or as easy as any of us would like it to be, but attachment has to be considered. So this bill would put attachment in the mix, and it would require that we recognize that some foster parents have developed attachments at some point, and we have to respect and consider them. There is some concern that I might have about whether we're preferring the attachment versus considering the attachment, and I think we need to be clear there because I don't want to go from one frying pan into another fire with the confusion of preferences. I think after thinking about this for the longest time, I would rather just see us just consider the best interest of the child and have it be clear, but that is something that we need to consider and debate within the legislative process. And finally, the piece that I'm, not finally, but almost finally, the piece that I'm really happy to see is that we've had long-standing practice in one direction with DCF, but it hasn't been consistent across our state through no fault of anyone. A person who might be in a leadership role believes that they're following a certain statute or a certain policy in a certain way, and that's the way that everybody in that area learns to do business. And then you go to a different area and someone else reads it slightly differently, and it's not wrong, just slightly differently, and then they learn to do something very different. So often if you have adoption workers moving from place to place, you have them saying, wait, that's not how you do it, and people saying it is too how you do it. So we have the opportunity not only to address the policy that DCF is following, and the courts are following, but to have DCF really look at, can we improve our policies and procedures, implement them consistently, and ensure that we've provided the training so that we can go in the direction that the legislature decides is the policy decision they want to make. I would echo the concern that Crystal raised about the provision for appeals. To go a little bit back into the legalistic piece, currently, it's not written anywhere in statute, but if you're not happy with how your adoption selection decision is made, you do have the option to seek private counsel, file what we call a motion for no reasonable efforts, go to court and request the court to look back at that section about court making direct placement and choose that route. That is very extensive, and it's all directed by case law. So what that means to me is we do have right now a right to access district court, but we don't have that right to access the appellate court. And I have concerns about all of those cases that currently are uncontested turning into contested adoptions and potentially opening that long, long delay for children to really know, where is my home going to be? And so those are my concerns. I hope that was helpful, and I'm happy to stand for questions.
Thank you, Rachel. So we'll open up questions now to, well, before we do that, let me direct your attention to some written testimony from Carrie Leonard. Carrie, were you written only? Okay, all right, thank you. So Carrie Leonard from the Department of the Child Advocate, and Angela Hedrick from KVC Kansas. So that's the written only, and those are all of the proponents we have. So do you have questions for either of the proponents? Did I see your hand up? Representative Lewis.
Thank you, Madam Chair. I'm sorry to keep going back, but I still don't get. Okay, one question. Maybe I understand now, but I'm not sure. This amendment sets forth the factors that the secretary should consider with respect to foster care parents. But it doesn't say anything about what the court should consider. And am I to understand what you're telling me is that that's already established by case law, so there wasn't I mean, we could tell the court what to consider, could we not?
Correct, Representative. One of the issues is at the front of this, I'm happy to loan this, and we probably just need to get you one of these books, is that the beginning of this statute says the court shall be dictated by the best interest of the child in making all decisions. So that probably answers that a little bit, is that best interest of the child decision.
Just to follow up, so, I mean, if we want the secretary to consider foster care parents, why aren't we telling courts to do it if they're making the same decision?
I think practically speaking, because the actual application of that section is so very limited that it's almost not something that the court needs, because they only go there once a person who has been frustrated by not being selected as an adoptive resource takes their motion for no reasonable efforts to court, and then the court does have a section of case law factors to follow. So people aren't seeing that as a concern, so that's why it's not in the bill, really.
Thank you.
Okay, further questions for, what's your name? Rachel?
Rachel Marsh.
I'm just kidding. She's a good friend. Rachel or Crystal. Representative Humphries.
Yep. Thank you, Rachel, so much. And thanks for, that difference between A1 and A2, that I had forgotten, we had talked about that dispositional hearing. But, in your career, how often have you seen number A2 happen instead of A1?
I can't rely as much on my memory these days, but I don't recall it ever.
Ever, yeah, it's quite unusual.
It's never used unless you have a contest.
Unless it's a private adoption, like we had talked about before. So, yeah, but it's part of the statute, so we need to have it in there, but it doesn't happen very often, is my recollection. And then the question about the courts versus the secretary making the decision, that was a question that the Oversight Committee asked several times, I feel like. So the courts make the decision if a child is adjudicated as a child in need of care. But then when it comes to choosing the adoptive home, it's really the secretary that is making that decision, and the court goes along with it. Basically does a decree of adoption, but unless someone does file that motion for reasonable efforts or not. But otherwise, it's really the secretary that's making that decision. Is that correct?
Correct.
Okay, thank you.
382270, oh my gosh, I need to get new glasses. I can't even read it. It puts the total authority with the secretary to select the adoptive family, and no further consent is needed to finalize the adoption. And so what happens, practically speaking, actually, is that you move from the child in need of care code, you do the adoption packet for the adoption attorney, and they actually file it in probate court.
So that begs the question, why did that just happen? In a recent case that was in the news, that the secretary did make a decision and the court overruled it.
I will stand by the fact that I do not know the facts of that case. I would be prohibited from knowing them by the fact that it would be a misdemeanor for people to share information with me, and I don't know what the court orders were to understand the legal.
Okay. All I know is what I read in the paper that.
You're right. I don't trust what I read in the paper about what courts say.
Oh.
No offense. Should I sit down now?
No, you don't have to sit down, Rachel. I just hope, I thought maybe that you had a quick answer to that question of why that would happen.
I'm somewhat bewildered by the whole
Okay.
media.
Okay. All right. Further questions for Crystal or Rachel? Wow. Okay. Thank you. Okay, that's all I show for proponent testimony. I have no neutral or opponent testimony listed, and so I'm going to close the hearing on House Bill 2299. With other business, I'll call on Representative Ousley.
Thank you, Madam Chair. And committee, I just need to make a correction. The wrong RS number was given the other day for the bill introduction. It should have been RS 0891.
What was that bill regarding?
Oh, the Communities at Care Survey.
Okay.
Thank you.
Okay. That doesn't require any action on our part. We just need to make a correction in the record. So committee, we have a little bit of time. Might want to take a look at a couple bills. Could you pull out House Bill 2240 regarding that notification, kind of a technical issue? Jesse, would you give us a quick overview of that bill?
Thank you, Madam Chair. House Bill 2240 relates to 382291, which requires the secretary to notify when children have been placed in a qualified residential treatment program. And then it states to go on, written notice shall also be given to, and lists another list of intended recipients, but does not state who shall send that written notice. This bill amends to state that the clerk of the district court shall give that written notice.
Okay. Committee, do we have any amendments for that bill? Okay. Representative Neighbor? No amendments. Doesn't look like it.
Madam Chair, I would move that we pass out favorably House Bill 2240 favorably.
Okay. Is there a second? Okay, it's been moved by Representative Neighbor to pass out favorably, second by Representative Humphreys. Is there discussion? I know this is a tough one. Okay, Representative Neighbor, you may close.
I close.
Okay. All in favor signify by saying aye. Aye. Opposed, no. Okay. We've done some heavy lifting there. So we also have, still in committee, we have the human trafficking bill that we heard Monday. That's House Bill 2153. And Jesse, would you give us an overview of the bill?
Thank you, Madam Chair. Committee, House Bill 2153 authorizes the Attorney General to coordinate a training related to human trafficking awareness. And then it goes on to require that training be taken by certain child welfare agencies, juvenile justice agencies, mental health professionals, and school personnel. And that is House Bill 2153.
So I had indicated to at least one committee member that we might not work this bill till next week. We can have some discussion on it, but I would entertain a conceptual motion to amend if we're ready for that. Representative Pickert, would that work for you?
Yes, that would work. Thank you, Madam Chair. So when we had our discussion earlier in the week on Section 1, it was a little bit confusing about the law enforcement agencies, and we thought maybe wordsmithing it just a little bit more to maybe take out some extra words. So I don't know if any of you have your bill with you, but yeah, just the amendment, yeah. It's really pretty easy, but so on line 13, to cross out the word team and cross out intervention and reports and add in cases. So it would read, it's hereby declared to be the public policy of this state that law enforcement agencies shall implement a coordinated multidisciplinary approach to cases involving alleged human trafficking, aggravated human trafficking, or commercial sexual exploitation of a child. Does that make it more clear? It does to me.
Does it? Yeah. It does. It makes sense. Would you like to put this in a form of a motion then?
Okay. Yes, Madam Chair. I move that we make the changes as I just said. Okay. Is that good enough?
Yep.
Is that enough? Okay.
All right. It's been moved by Representative Pickert to amend, second by Representative Underhill. Is there discussion? Representative Humphreys.
Not seeing it right here, but I feel like there was one other place that we mentioned reports. I could be wrong. Oh, yeah. It's in B. I didn't know if, I mean, I need to read it more carefully right now, but sort of some of the same language is mentioned in B as is in A, and so I don't know if we'd like to include that,
Are
or,
you looking at line 18?
yes, Yeah, just would want to be consistent in the way we have the statute written, but it may be two completely different things, so let me,
I think
Representative Pickert?
to be consistent, yes, we could remove the word team. Just have it multidisciplinary approach. Yes, and yeah, and just consistently say, go ahead and cross out team approach to intervention in reports and add cases in there, like the above
Are you saying
paragraph.
to consistently in the bill replace the words reports with cases? So that they're not making, okay.
Intervention to reports.
Okay, Jesse, do you have any comment on that?
Yes, Madam Chair, I would just like to clarify the amendment. So in line 13, we are striking team and intervention in reports and inserting cases. And then in line 18, the amendment is striking team and striking intervention in reports and inserting cases.
If I could amend my amendment,
You can, since it's your amendment, you can.
yes, that would be,
the second half.
that's what my intention is, yes.
That's your intention? Okay. Is that okay with you? Okay. Okay, can we give you permission to correct that? Okay. Well, okay, go ahead, Jesse.
Thank you, Madam Chair. The comment was to change the word reports wherever it was in the bill to cases. I would like to clarify that this amendment does not do that. This only changes reports to cases in these two instances.
Okay. Okay, that's, okay. Is there further discussion?
Yes, ma'am.
Representative Underhill, I'm sorry, I forgot to call on you.
No worries, thank you. Yeah, I just wanted to reiterate with the other representative that I think removing the word team alleviated any concerns that law enforcement had because they already take the approach. It was the word team, so that's why I support it.
All right, other discussion? Okay, Representative Pickert, you can close on your amendment.
So I move that Bill HB 2153 be passed out of the committee favorably. Is that what, oh, not in my amendment, okay.
Just on your amendment.
Okay, so I move that the amendment be accepted.
You can just say I close on my,
I close on my
motion.
amendment. My motion.
just close on your motion. Yes,
Okay,
all right.
got it.
Okay, all in favor say aye. Opposed, no. Okay, the bill's been amended. Are there further amendments? Representative Johnson.
Yes. I would move that we amend on page 1, line 33, where it says the word employees, and insert the word counselors. Counselors. So it would read all teachers, administrators, and counselors of any public or non-public elementary school. The basis for this is you're placing an incredible burden on a school district if all employees, because that includes bus drivers, substitute teachers, kitchen help. It's just almost impractical. And I think the goal is to get the teachers, the administrators, and clearly counselors involved. And that's the basis on that amendment.
Okay. Is that a second? No. I'm looking for a second to the motion to amend. Oh, Representative, we have a second by Representative Wagoner. Okay, now discussion. Representative Howell?
While I understand the maker of the motion's concern, I will just share with the committee that I have a close family member who was sex trafficked, and not a single one of us in the family realized it. And that makes me very nervous to make that replacement. We all need to be educated down to the janitors to know what we're looking for. And just, I realize this is not sex trafficking and there's some differences there, but just as an idea, what if we were to consider changing the every fiscal year a little bit instead of employees, just for the sake of discussion, so that it would provide a little bit of flexibility for the employers on getting the job done and how often it was done, but yet everyone would receive education, just for discussion.
Okay. So just for the purposes of discussion, we'll stick with just this amendment, but if you'd like to offer that one, we can go return to that. Representative Neighbor.
Thank you, Madam Chair. You know, in the cases of abuse and what we all see or are privileged to see or not see, sometimes it helps to have more eyes on the issue than just some. Counselors are great, and they're going to have day-to-day, not day-to-day, but they will have more access. But I believe then you are limiting the sets of eyes when you just place it with certain people in schools, because sometimes custodians hear things and see things and can present things. Bus drivers, they may see things and hear things on buses that no one else knows about. And while it may be a very large group of people, I believe that within a school district, whether you do it through video or if you do it through your staff meetings or however you arrange that, that can be completed with more eyes on the possibilities. And so I guess I would be opposed to the amendment, just that I think it limits and doesn't give us as many out there. Thank you.
Representative Johnson.
Thank you, Chair. With the approval of my second, I would like to withdraw my motion.
You got his approval, so that motion to amend has been withdrawn. Were you interested in amending?
Can I ask Jesse a question?
You sure can.
Do you think making that kind of a, well,
There were 3 bills that were brought up. He had me take one. I mean, they were ones we had last year. The mic on. Representative Howell?
Thank you, Chair, for the patience and the whole committee. So after a little discussion and thought here, I think I would like to make a motion that on line 23, I just want to strike 1 hour of those 3 words. So we'll leave each fiscal year, but we'll remove the 1 hour of.
Okay, we've got a second motion from Representative Howell and a second by Representative Wagoner to amend. Is there discussion? Would you like to explain your rationale?
I'm just thinking that it gives everyone a little bit of flexibility on how much time is invested in gaining this knowledge, and just to provide a little bit of freedom for the employers, and so they can look at the courses that are available and decide what is appropriate and what is reasonable for them to afford to do. I'm trying to just think of what's best and most practical for all these. I mean, this is a broad amount of people, which I think need it, but give some flexibility for how to do that.
Okay.
In a practical sense.
Representative Wagoner.
Yeah, I would just throw in the same, I mean, so it would read, each fiscal year, the following person shall be required to complete training on human trafficking awareness and identification that has been developed or approved by the Attorney General. I think that is sufficiently, broad, and it makes it sort of part of it. A lot of organizations have annual training on safety or health issues or whatever, and, whether it's an hour, whether it's whatever, but it does make sure that the topic always comes up, and sort of, I think, it's a good balance between making sure that you have the training without having it being overly burdensome. And it's not to say that you wouldn't have like 1 hour training or 2 hour training or whatever, for first-time employees, but it doesn't sort of handcuff the organization so much.
Okay, further discussion? Representative Neighbor.
Thank you, Madam Chair. I think there was also discussion on this, saying that the AG's office has a program. It was an hour long, but there are other certified programs out there, and I think the issue is certified program, and they can provide that. If they do that, a lot of times, if that's on WebEx, it's not going to cost anybody anything. And so I'm not going to say it's never going to charge you, but they said they would do it for free. But if it is accessible, hopefully we wouldn't have those charges incurred or placed upon a business that would make it difficult. So, and maybe they all come in at an hour. We don't know. Thank you, Madam Chair.
Further discussion? Representative Ousley.
Thank you, Madam Chair. And just for the committee's consideration, I seem to recall this topic coming up during the hearing, and complete up to 1 hour of training, I want to say was mentioned. That way, you're at least capped at the hour, for consideration of time and expense of the employer. I just throw that out there for consideration.
Further discussion?
Madam Chair,
Representative
I brought
Neighbor.
that up as a question when we did work the bill. So that would be even more open. I mean, well, they're both open. So, but you could say up to 1 hour, so it doesn't go over and cause a problem.
Representative Pickert.
Thank you, Madam Chair. I think it would be a good idea just to leave it open because I'm thinking for some professionals, they may need a whole day, daycare, maybe 30 minutes is plenty. I mean, just make it as flexible as possible just so they get what they need. That's my opinion.
Representative Howell.
Thank you, Chair. I believe I'm also remembering when we worked the bill that, or had the hearing, that the that the Attorney General's office, too many committees, the Attorney General's office talked about having an approved list, that they were going to make an approved list of different trainings that business owners or whoever could select. So that also gives some flexibility in there.
Okay, further discussion on the amendment? Okay, Representative Howell, you can close on your amendment.
I close, thank you.
Okay. All in favor of amending, please say aye. Aye. Opposed, no? Okay. All right, any further amendments? Then I'd ask for a motion on House Bill 2153. Representative Neighbor. Some committees just have like automatic people that they go to for the motion. And
Thank you, Madam Chair. I would move that we pass out House Bill 2153 as amended favorably.
Okay, it's been moved by Representative Neighbor and seconded by Representative Johnson to pass out favorably as amended. So further discussion? Okay, Representative Neighbor, you can close on your motion.
Madam Chair, I close.
Okay, all in favor, please say aye.
Aye.
Opposed, no? All right, we've passed another one. All right, that's it for today. We'll see you Monday. We have scheduled, what do we have scheduled? Yeah, we have something Monday. Okay, we're adjourned.